Hey class, Mr. Stewart here. Sorry for the lateness in regard to this week's video. There has been a lot of integrity issues over the last week or so, and hopefully those things are getting ironed out now. The good thing is that we are now going to be going away from integrity, I think, as of next year, but we're going to be stuck with it this year. But we are getting a new type of video platform called Camtasia, and hopefully we'll be able to get into that before this term is over, maybe, and you can start seeing some things in regard to that. Anyway, I was sick the first part of the week, and just wanted to apologize for being a little late in my responses this week, but and I'm still not feeling great, but I'm going to make this video fairly short and just cover a few things that students typically get kind of hung up on in regard to these two chapters. This week you've been tasked with reading chapters 2 and 3. Chapter 2 is important aspects of the American criminal justice system, and chapter 3 is using evidence to determine guilt or innocence. So there's a couple things in regard to chapter 2 that I think are pretty important for you to understand. And as soon as I can change this slide. I want you to make sure that you are familiar with federalism. And what federalism is a division of power between the state and the federal governments, in which the federal government has very specific powers that are enumerated within the Constitution, and then the states are left with whatever powers basically have not been given to the federal government. There is a division of power, there is a separation there, and that's what makes all of our states different, is because every state has a little bit different rules, a little bit different laws, a little bit different customs and traditions, cultures, etc. And hopefully the state's laws and rules and regulations are similar with the culture in that particular state. And then we are a combination of states. We are united under one single constitution. And so we have a state, every single state has its own criminal justice system, and then the federal government has their own criminal justice system, and sometimes they intersect, but as a general rule there is that division of power. So just want you to understand that. Let's see, I don't want to spend a lot of time on federalism, but make sure you read the section where it says the federal rules of evidence, when they were enacted, and the fact that most states also have their own rules of evidence that are very similar, if not identical, to the federal rules, simply because the federal rules of evidence are good. It provides a very fair way of determining whether evidence should be admissible in a criminal case or not. So I don't think you guys should look at the fact that the state's own rules of evidence are identical to the federal as being any type of government overreach or anything of that nature. It's simply the federal government got that right, and the states kind of followed suit for the most part. So just understand there are some very specific procedures and very specific rules for what can be considered evidence in a criminal case and how that evidence can be admitted at trial or in a criminal case. So make sure you read that section in your textbook. Every state does retain the power to interpret and modify those rules of evidence, and most of the time the rules of evidence not only apply in the criminal venue but also in the civil venue as well, although there are some differences. For example, hearsay is not admissible in a criminal trial, but it is admissible in a civil trial. And what hearsay is you can't get on the stand and testify in a criminal trial that, so-and-so said that the defendant killed the victim. You can only testify to what you have personal knowledge of. However, in a civil case, because there's no real abridgment of your freedoms if you lose it. Hearsay evidence is admissible, and basically all you have to do to win a civil case anyway is just tip the scales in favor of one side or the other, whereas in a criminal case you have to overwhelmingly prove that case beyond a reasonable doubt. The 10th Amendment is really what kind of gives us this idea of federalism. It says the 10th Amendment of the U.S. Constitution states that powers not delegated to the states are reserved to the delegated to the United States are reserved to the states or the people, and that means that whatever powers are not given to the federal government are then delegated or reserved to the states themselves, each individual state or the people therein, to make whatever laws or give the citizens of that state whatever powers or freedoms that they choose. Now, they cannot be, I guess, less restrictive than what the Constitution allows, but they can put other restrictions on there. That's why states are what they are. That's why we have individual states and not just one big, huge country with no geographical, political, or governmental boundaries. There's some cases in this, and this is the important part of this particular textbook, and this is one of the reasons why I chose this textbook, is there are cases in this book that, and these cases are not here for you to overlook. These cases make good points, and so make sure you read the court cases in these texts, and if you have questions about them, feel free to text me or send me an email or something, and I'll be happy to try to help you work through those things. But the court cases are the examples of either the case that brought about a particular rule or a particular case law, or it was the reason why something was developed at a later time because the court made some sort of egregious error or something like that. So make sure you're reading those cases, because they're definitely applicable in this particular class. As far as jurisdiction goes in regard to with this whole idea of federalism, understand that the federal system has their own set of laws, and each state has their own set of laws. Each state is responsible for enforcing their laws, and the federal government is responsible for enforcing their laws. With that being said, sometimes crimes can overlap, which means you could theoretically engage in one criminal act that could be both a violation of a state law and a federal law. In that case, you could be prosecuted by both entities. But most of the time, the federal government's not going to prosecute you for a violation of state law, and the state government's not going to prosecute you for a violation of the federal law. The only time you would get prosecuted in both would be as if that crime is considered a crime under both sets of laws. Hopefully that makes sense to you guys. This is important too, because this is something I think sometimes our government has forgotten. The U.S. Constitution does not grant the federal government a general police power, nor has there ever been federal criminal common law. And what common law is a set of unwritten legal rules that have been developed over many years by courts and judges. This is kind of what our law was originally designed after, because that's what British law was. But we very soon, after forming our own country, began to codify our own statutes and determine what we wanted to be crimes and what we didn't. And because of that, we really aren't based on common law any longer. All of our statutes now in every state has been codified, which means that the state got together and decided the very specific things that they wanted to be illegal or acceptable. But the federal government does not have general police power, which means that's why you have so many different federal law enforcement agencies that only handle very specific things. For example, if there's a murder and it doesn't have anything to do with crossing state lines or anything like that, then There's no federal agency that's going to investigate a standard run-of-the-mill homicide. That's also why you have the examples like the DEA. They're going to investigate drug offenses only, federal drug offenses. The FBI is responsible mainly now for counterterrorism, bank robbery, and some white-collar crime that crosses state lines. The ATF is responsible for the federal alcohol, tobacco, firearms, and explosive laws enforcement. Other than that, the general police powers are reserved for each individual state. That's why you see, a typical city police officer or county deputy sheriff, or in states that have a state police agency, they'll handle such a large amount of crimes that and they may start their morning out with writing a traffic ticket, then go work in a bank robbery, and end the day with a homicide. That'd be a real busy day if that was the case, but I'm just giving you that as an example because they do have general police powers, whereas the federal law enforcement agencies have very specific police powers. So I just want you to make sure you understand that. Now, the other thing I wanted to talk about in this particular chapter, I'm going to skip through some slides here. Just want to make sure that you understand this. Give me just a minute to get to it. It's the fact that our justice system in the United States is considered an adversary system, as opposed to other countries who have more of an inquisitorial system. Now, don't let this term adversary get you thinking that it's about a good guy versus a bad guy. That there is an adversary, which we typically think is an enemy. An adversarial system of justice simply means that you have two sides that are competing for the legal truth. There's some competition there. Both sides are trying to get you, i.e. the jury, to believe that their side is correct. They're trying to find the legal truth for the purposes of determining guilt or non-guilt. Also remember, we do not find people innocent in the United States because the burden of proof is upon the prosecutor. We only find people guilty, or we don't. Now understand that if we don't find you guilty, it's the same as being innocent, because we don't punish those that we don't find guilty. But just because you get acquitted at trial doesn't mean that somebody is innocent. It simply means that we couldn't prove your guilt beyond a reasonable doubt. Now this adversarial system is unique to our country, whereas most other countries have something more like an inquisitorial system where you have to prove that you are innocent. In the United States, you do not have to prove innocence. We have to prove guilt. The prosecution has the burden of proof to prove guilt. The defense actually does not have to prove a single cotton-picking thing at trial. They could come up, they could say, we rest our case, and not say a word. Now that very rarely happens, but it could happen. For the reason is the prosecution has the burden. They have to prove beyond a reasonable doubt that you're guilty. Now in many cases, if the defense did not provide some sort of defense, then the jury only has one side to go on, and so you could present a really bad case to a jury, and they probably still find you guilty if the defense didn't put on some type of evidence. But what the defense strategy usually is just to create that shadow of a doubt in the mind of the jury. And that would decrease that level of proof that the jury had in their mind that the prosecution met. So just understand that the prosecution has a big hill to climb to get a conviction. And this is the reason that so many people get arrested and very few of them actually go to prison. I think the last statistic I saw was that for every 1,000 crimes that are committed by 1,000 different people, we send about 5 people to prison. And people say, well, that's not justice. Justice is not being served. Well, I think justice is being served because we are going through a process and we are protecting the rights of all parties involved. And if we did not protect the rights of everyone, if we trampled on the rights of the accused, how long would it be before the rights of those who weren't accused, the rights of the victims, were also trampled upon? So I think our process is much better than most other countries' criminal justice processes are. And so I just want you to make sure that you are familiar with this whole idea of an adversarial system of justice, because it's important to understand that with the way our system works. So you can read over those slides. You can read that section in the textbook too, but I just trying to clear some muddy water a little bit. Again, I'm gonna skip over some slides here. This next one I want to talk about is the fact that any evidence that is presented in a criminal trial in the United States must be relevant, reliable, and competent. If it is not all of those things, it is not admissible and it cannot be used at trial. What does relevant evidence mean? Relevant evidence is direct or circumstantial evidence that has a tendency to make a material issue before the court more or less probable. It means it is directly connected to the facts of the case. You know, if you're investigating a murder and all of a sudden you want to bring in let's say a murder and the defendant is 56 years old and they've never had a conviction for a crime before in their life. They've been an upstanding citizen, and the prosecution wants to introduce some sort of drawing that this person made when they were 6 in first grade that is trying to tell you that tells you the nature of their character. That's probably not going to be relevant. If it was something they had done 3 days before the trial, maybe that would be relevant, because it may show their state of mind at the time of the offense. But we're talking about 50 years ago. It's a wonder it would still be in existence, but I'm just using that as an example that would not be relevant. Reliable evidence is evidence that possesses a sufficient degree of believability, and that means the evidence itself appears to be true and correct, or the testimony given by somebody appears to be credible, or the source that is providing you the evidence also is credible. They're deemed to be a reliable source. Each state has the authority to commence a criminal prosecution if sufficient evidence is available to justify the criminal charge. So not only does the evidence have to be directly connected to the crime, it must be reliable, which means it's believable, and then it has to be competent. And that basically includes relevant, reliable evidence that is not otherwise rendered inadmissible, such as communications between a patient and a physician. Let's see, those are not admissible. That's not considered competent evidence. Evidence seized in violation of the Fourth Amendment is also not considered competent evidence. So just to understand that basically competence means that if it is relevant, if it's reliable, and there's no other reason that it should be deemed inadmissible, then it's probably going to stand on its own and be considered competent. Hopefully that makes sense to you guys. So go ahead and finish reading this chapter. Read about the accusatorial system. That's kind of some of the foundations of our system. And then in the last part, it goes ahead and talks about the inquisitorial system, where basically they almost rely solely on confessions. And here in the United States, we don't necessarily rely solely upon confessions, because we know that confessions can be coerced. Sometimes people confess to things that they didn't do. So there has to be more to the case than simply a confession. But the inquisitorial system is about, proving innocence and putting a lot of emphasis on confessions. And understand that in some cases, countries that use this inquisitorial system can put pressure on a defendant to confess just in order to close the case, which means they may use unethical procedures such as beating someone to the point that they're in severe pain, discomfort, or almost death, and then asking them did they do the crime, and tell them that if they confess, the beating will stop. So they confess, the beating stops, and then they go ahead and consider them basically guilty for that crime because they confessed, and then they probably go ahead and execute them or something like that. So the inquisitorial system is just not a good way. Now I'm talking about this was more, the execution was more done in medieval times. Since the Renaissance time, it's been more incarceration than execution, but still they sometimes coerce confessions, and even then they may make it sufficiently uncomfortable that the person just goes ahead and confesses, and that's the only piece of evidence they have. So also read about disclosing information in the adversarial system. Read about alibis and alibi statutes, the duty to disclose, the Brady rule. Make sure you read those things. I know this is a lot of information, but this is what you're going to have to get in your head because it's going to help you understand the rest of the course. Also read about lost, misplaced, and destroyed evidence, the use of false or perjured. That means evidence that is incorrect, that somebody's lied. Again, there's some associated cases that make those examples as well. And I think that's all I'm going to cover in regard to Chapter 2 here. I want to move on to Chapter 3 just a second here. Chapter 3 is asking us to outline the criminal court process, list the pleas a defendant may enter to a criminal charge, evaluate the pros and cons of plea bargaining, compare the use of evidence at various stages of a criminal trial. Now, the criminal court process, if you have had intro to criminal justice, you've had the criminal court process at this point. So you kind of, and if you've watched Law and Order or any TV show, you're probably familiar with the criminal court process. But you need to make sure you read over that because what you see on TV may skip a few steps. Typically, it does. Also, read about this evaluation and review of the evidence. Every piece of evidence that is admitted in a criminal trial in the United States goes under some sort of scrutiny or some sort of review. Evidence isn't just immediately considered admissible. The prosecution has to ask for a piece of evidence to be admissible. The defense gets to question that if they want to. And then it's up to the judge to make a determination whether that piece of evidence should be allowed and the jury should be able to see it. And the same way with the defense. If the defense wants to bring a piece of evidence in proving their client was not guilty, then the prosecution gets a chance to question that. So not only do you get a chance to question witnesses, but you get a chance to question physical evidence, those things that were maybe collected from the crime scene as well. So every piece of evidence goes through an evaluation, a review process, some degree of scrutiny before it is admitted at trial. And every state does it a little bit different, but every state goes through this process of some sort. If some evidence has been obtained unethically or illegally, then one side or the other has the ability to file a motion to suppress that evidence. And that means that, hey, this should not be deemed admissible. For example, I served a search warrant one time, and the defense attorney filed a motion to suppress the search warrant because he thought there was something in the search warrant that was incorrect based upon what his client told him. So we had a suppression hearing, and that was a hearing before a judge with no jury or anything was present. It was the prosecution, the defense, the judge, and me, which is the person that had obtained the search warrant, to try to determine whether that search warrant would be deemed admissible or should it be suppressed. After we went through the hearing, the judge determined that even though there was a slight error in something in the search warrant, it was not a large enough error to make a difference. So he did not suppress the evidence. It was deemed admissible, and we went on, and instead of going to trial, we ended up going through a plea bargain process because the guy did not want to go to trial after the search warrant and what we found during the course of the search was deemed admissible evidence, because if it had been suppressed, then we wouldn't have had a case against him, basically. But because it was not suppressed, we had a case, and so he just went ahead and took the easy way out and did a plea bargain. Again, more cases. Read over these cases. Read over these goals of the criminal justice system. The generally recognized overall goals are to discourage and deter people from committing crimes. If we could do that, our job would be so much easier. However, we're not going to discourage or deter everybody from committing crimes, so we do have to protect society from those people that do. And the way we do that is we punish those that we find committing crimes, and after punishment, we should be rehabilitating them so that when they get out, they don't commit another crime. I think that's a part where our system has fallen down, in its responsibilities in the last several years, for sure. So read over this criminal court process. It's really straightforward. It's the same as what you probably had in Intro to Criminal Justice. It talks about pleas. Now, understand that when a criminal defendant is charged with a crime, they come to court, and the defendant has the ability immediately and they have to enter some sort of plea. Now, most pleas that are entered that result in a trial are not guilty pleas. The defendant says, "Hey, I'm not guilty. I didn't do it." In that case, then the state has the burden to go ahead and take you to trial and try to prove your guilt. You can enter a guilty plea. This is typically what we call a plea bargain. If a defendant decides to say, "Yep, I'm guilty. I did it. Please punish me," then typically there's been some sort of deal worked out between the defense and the prosecution to give that defendant some lesser amount of punishment than what they might receive if it went through with a trial. Understand, a not guilty plea is going to result in a trial. A guilty plea is probably going to result in the trial process being cut short and some sort of more lenient punishment given. You can also enter an insanity plea or an insanity defense. Usually this plea is not guilty by reason of mental disease or defect, and that means that the person could not appreciate the wrongfulness of their actions, and therefore, because of their mental defect or their mental illness, they should not be punished. Even though they did commit a crime, they shouldn't be punished for it because of their mental issues. This is something that also will result in a trial. If you plead insanity, then it's up to the jury typically to make a decision to determine if you were actually insane or if you knew what you were doing. Some people also plead a nolo contendere or no contest plea. And what that basically says is, I'm not admitting that I did this crime, but I think you have enough evidence to convict me of it. And it carries basically the same punishment as a guilty plea, but it's not actually admitting guilt. Not every state allows a no contest or a nolo contendere plea, but many of them do. And then the defendant could also stand mute and not say a word. Typically in these cases, the court will enter a plea of not guilty, and then we'll go through with a trial for that defendant. Read over these purposes of the rules of evidence, and basically that is to make sure that the defendant receives a fair trial, that it is as fair of a process as possible, because we don't want people who are lying, cheating, stealing to be able to provide information, or the police to be able to go and illegally obtain evidence and get that submitted or admitted at trial. So read over that section. It's also really straightforward as well. And then I think some of these slides here, they go on, they talk about these pleas that we just talked about, the not guilty plea, the guilty plea, the no contest plea, the insanity plea. Just understand the insanity plea. is effective usually about 1% of the cases that it's tried in. It's not as effective as TV would like you to believe it is. Very rarely does the court actually find somebody insane. And understand that even if they do, it doesn't mean that person's going to walk free. It simply means that instead of going to prison, they're probably going to be put in a mental institution for an indefinite amount of time, or until such time as they have been rendered sane, so that they're not a danger to themselves or the public. Read over the plea bargaining process here. This is basically when the prosecution and the defense play let's make a deal, and they develop some sort of lesser punishment if the defendant will forego a trial and just say, yeah, I did it. Many people don't like it, but it does make our system much more efficient, because there's no way we could have a trial on every single case that comes into the courts. Victims' rights are also important. That's something that we've begun to look at in the last several years to keep in mind that during plea bargaining, during sentencing, during whether or not we have a trial, we're also keeping in mind the victim's rights and kind of what the victim wants to a certain degree in the case. It's more of a consideration than it is something that the courts have to do, because in most states, and especially in the state I was a police officer in Tennessee, it's up to the prosecutor. The sole discretion to take somebody to trial or to enter a guilty plea is up to the prosecutor, and they could completely go against whatever the victim's family wanted or the victim wanted in that case every time if they wanted to. Just understand that if they're an elected district attorney, that may not work out so well with them in the next election if they don't take into consideration what the victims in cases want sometimes as well. So it's kind of a hard job, because as a district attorney, you're stuck between the public and politics. All right. Talks about the trial, talks about the bail process, talks about the sentencing process. Again, more cases. So it's pretty straightforward, and I don't think you'll have any trouble understanding anything. I just want to try to clear some of the muddy water that students usually have in regard to these two chapters. And next week, guys, I'll try to get this video posted on Monday or Tuesday instead of Thursday, and hopefully this will work for you. If you have any questions, make sure you reach out to me. I'm here for you. I'll be finishing grading and responding to discussions the rest of this week and first part of next week. So have a good week, guys, and I'll see you soon. Bye-bye.